I'm excited to introduce my guest today, Melissa Bustarde. Melissa is an M&A attorney who specializes in representing buyers and sellers involved in transactions of $10 million or less in enterprise value. At a time when attorneys from every background are rushing into the lower middle market space, Melissa stands out as a true expert, someone who genuinely understands the nuances, complexities, and real-world challenges of these deals. Her personal story is just as compelling. From a young age, she knew she wanted to become an attorney, following in the footsteps of the person she admired most, her father. After college, she began working for an attorney who became both her mentor and champion. In an inspiring full circle moment, that mentor eventually sold the firm to Melissa. She became the owner. Then later, she acquired and merged with another firm, ultimately becoming a partner in her very own law practice, all while successfully balancing life as a wife, mother, and prolific networker. Sit back and enjoy Melissa's remarkable story.
You don't want to ask your neighbor who's a personal injury attorney to help you with this transaction. You don't want to ask your best friend from college who's a family law attorney to help you with this transaction. You really need someone who's works and is well-versed in the M&A space and specifically in the small business size space. There's lots of attorneys who say that they can work on the M&A deals because every single attorney took a contracts class in college. And they all think, oh, well, it's just a contract. I can deal with that, right? Make sure that they're actually working in this area and are familiar with the smaller business transactions, because if they're not, it's going to drive up the price. Whether they're usually at big firms, but whether they're at a big firm or a medium-sized firm, they're going to cost more. And quite frankly, they end up overcomplicating the deal.
Melissa, welcome to the podcast.
Thanks for having me.
Yeah, I'm really excited to have you here, talk about what you do as an M&A attorney and general counsel for small business owners. That's my audience. If you wouldn't mind, please give us an introduction of who you are, how you got here, and what's on your desk today.
Sure. So I am a managing partner of Branthman, Mayfield, Bustarde, Ryckanthal LLP. It's a mouthful, I know.
All are, right?
Yeah. So we go by BMBR
there you go.
For short. And I am a transactional business attorney, and I really focus on working on small businesses, small business deals, and counsel services for small businesses and small business owners. So I kind of have an interesting story. So I knew from a young age I wanted to be an attorney. My dad was an attorney, and he was the smartest person I knew. And so I figured if he could do it, that I could do it.
I love it.
So from early on, I knew I was going to law school. But like most law students, I kind of didn't really know what area of law I wanted to do. I initially thought I wanted to be like a constitutional rights, First Amendment attorney. And then I found out like almost no one does that. So in law school, I ended up landing a job with a small business law firm here in San Diego. And I went in as a law clerk, which is what we call basically interns in law school. And here's the funny part is I've never left. I've been at the same firm my entire career. So I started in law school, and then after I graduated from law school, I got hired on as an associate attorney, and eventually I was made partner, and then I bought out the primary owner when she retired and became the managing partner. And since then, I've obviously bought out the partner, and then I bought another law firm and merged in with another law firm. So I've kind of been through all those different steps as a small business owner. That's kind of helped write my story on why I fit so well into these small business deals.
Well, this is an amazing story. We're not going to just go past what you just said. I want to make sure we sink into this. Tell us how you went from clerking to partner. What does that take? The reason I want to sit on that for a little while is because I think that'll be an inspiration for people.
Yeah. So if anything, I am certainly an extremely loyal person and a creature of habit. So, once I got into this firm and started working on these small business transactions, and my boss at the time really took the time to mentor me. And this was a second career for her. She had been in corporate America prior to becoming an attorney. So she kind of understood business acumen and making business decisions, which someone straight out of college and law school, right? I didn't really have that type of experience. And so she really kind of trained me on that. And so I became very loyal. I liked, I enjoyed the people I worked with. I really liked the clients that I worked with. And so I stuck around, and I was very fortunate in that I survived through the Great Recession because during that time, most of our staff got laid off because our clients were small businesses and they got hit really hard during the Great Recession. And unfortunately, legal budgets went out the window. But I was the only attorney staff member that survived apart from the boss.
What do you think actually kept you on staff? What did she see in you that she liked that made her say, hey, I want Melissa to stay on. And then also I want Melissa to actually take over what I built.
So I hate to toot my own horn, but
toot your own horn. That's what this is all about.
But, she's told me that she thought that I was extremely smart and that I was very ambitious, which has always been the case for me. If I, kind of put my mind to something, I'm going to do it and I'm going to make it happen. So that was, it was a mixture of those two things. By the time the Great Recession had hit, I had started going out and networking and marketing, which none of the other attorneys really did. They came to work and did their job, and that was kind of it. So I think that little bit of ambition and me trying to start building clients and getting clients for the firm certainly caught her eye. And I think she probably saw a little bit of her in me as well. And so we were definitely a good fit together.
So business development, ambition. I also heard consistency. And then the one that I think you were born with, being smart.
Yeah, that one I just lucked out on.
Well, you had a good dad, it sounds like.
I did.
Wonderful. What I'd like to transition to now is discuss your current practice in the M&A space. And what I want to make sure that I communicate to those who are watching and listening is that you do focus on what we call the lower middle market or small business. So that would be transactions, so M&A transactions with a sell side enterprise value of, let's say, 10 million or less. Does that sound accurate?
Yeah, I work on deals generally under 10 million. I would say the bulk of my work's under 5 million. I do have a few the outliers that have gone above that, but definitely the bulk of my work are sales, where the sale price is under $5 million. And I really focus on that small business space where I'll represent either the buyer or the seller, not both in the same transaction, but I'll represent either side and take them through the process. And I'm pretty flexible in terms of the deal size and how much legal counsel they really need, right? Obviously, the smaller deal sizes doesn't need as much legal work and legal expense as some of the ones that are on the higher end of the range that I work on. So a $500,000 deal, right? They don't need to spend as much in legal fees as a $5 million deal that I'm working on. And so I'm pretty flexible in that I try to tailor my services to the deal size and not overcomplicate things unnecessarily. I mean, I've dealt with sales as small as 100,000. I mean, to be honest, I've done a couple under 100,000. And those are really basic purchase agreements I put together, but I feel really strongly on servicing the small business community because I feel like they are the redheaded stepchildren of the business world and the legal world. And so I want to make sure that they get good work, but it's tailored appropriately to the expense. The expenses are tailored appropriately to their deal size. Yeah.
And that's why I love referring you business, because what I've noticed since we've had this deluge of individuals selling their businesses, the baby boomers, I see M&A attorneys who maybe they weren't making it, like you said, above the 10 million, 20, 30, $100 million enterprise value transactions. And they think to themselves, whoa, I'm overqualified. Let me go down into the SMB space. I'll kind of be an all-star because I've done all these big deals. And what I find is, though they do come down into the SMB space, the lower middle market, they don't tailor their fees. They're trying to get fees for $100 million deals that they're doing at $5 million. Right. And while really like referring business to you is because, like you said, you tailor your fees. But what I don't want anyone to think, because I've worked with Melissa directly on transactions, is that because she focuses on smaller deals, that you're going to get less of an attorney. In fact, what I would say is that you're going to get someone who can go toe to toe with the big players, because I've seen it. I've actually seen those contracts, and you do an amazing job. But also, this is your space. So you understand all of the deal points, you understand the nuances. And so you're in an advantage, in my opinion, because you're working in this space solely and you're focusing and you've made this your niche.
Yeah, I agree. And I really try to focus on things that are important for the client and not worry about things that aren't going to hurt them in the long run.
Yeah. And I've worked with those attorneys who have made the deal about them and not about the client. And they've cratered deals. And you don't do that. You focus, like you said, specifically on the client. You curate your services, you curate your fees. Can you talk us now through what it looks like when you work with a seller? Mm-hmm. And then I want to transition to a buyer. And then I want to talk about how, because you do represent sellers and buyers on separate transactions, how that actually helps you serve them both. Sure.
So when I work with sellers, ideally, I like for them to come in before they even take the company to market, because there's usually stuff in the small business world. Most of the clients are really good people and they're really good at what they do, but they tend to be not so good on the legal issues. Mm. And so we really prefer to dig in prior to going to market to kind of just do a little legal audit of their business to make sure everything's up to date. You know, are their corporate records or their LLC records up to date? Are they in good standing with the states that they do business in? Are their contracts up to date? Are their contracts with key clients assignable? That's going to be a really big issue when it comes to the sale. And their employment, tends to be where the small business owners get into trouble the most, is how they handle their employees and their employment records. Making sure everyone's classified properly as an employee or an independent contractor. Mm-hmm. Newsflash, they probably need to be an employee.
Yeah.
And you know, if their payment structure, their break times, their pay stubs, that all of that's in compliance with California law, is areas we like to dig in, because if there's problems, we need to know about it for the due diligence process, but we also need to clean it up now.
Yeah.
So that's kind of where we like to start. And then going into the deal itself, obviously we want to work with them through the LOI and negotiating the LOI. And then we can jump into the purchase agreement. And depending on the size of the transaction and the scope of services, we can either work through due diligence or just be on call to answer questions.
Mm-hmm. Do you have any geographic limitations? Can you tell us who your ideal client is? Where would they be located on the sales side? Mm-hmm. And then what size of a business? Again, we mentioned 10 million or less. And then what does the beginning of the engagement look like? And how are you typically referred into those opportunities?
Yeah, so I'm only licensed here in California, so I can only practice law in California. So as a result, most of my clients are here in California. Most of the sellers are here in California. There's been occasions where I've had cross-border deals, but usually there's a California connection. So it may be where I'm representing a buyer who's here in California, but they're buying a business in another state. I've done some of those, but I generally don't work on deals where there's no sort of connection at all to California, just due to licensing issues.
Got it.
Going into the engagement itself, so normally most of these clients are either pre-existing clients with my general counsel work that I've done. Yep, we'll talk about that later. But most of them have been referred into me, generally by other attorneys, CPAs, those in the M&A space like you, and then just kind of random one-off people that I know out in, the business community, because I tend to be pretty well known for doing these small business deals. And then my other big referral source are business brokers. I work a lot with business brokers who tend to work on the smaller size deals. And so they don't always have an attorney involved in their deal, but when they feel like one's needed or if the client asks for an attorney, they tend to bring me in. So I have a lot of great business broker relationships up and down the California coast.
Awesome. Can you talk to us about, from that initial engagement, you performed the legal audit, and then how that flows into the letter of intent? And if you can tell us what should be included in the letter of intent and what should not be included, and then how does a letter of intent then move forward to the purchase agreement?
Sure. So once they engage me, and I guess it depends in part on where they are in the process, because not everyone comes in as early as I'd like them to.
Got it.
So hopefully they haven't signed the letter of intent at the point they have engaged me. So the letter of intent is really important because it gives you a framework for what's going to be in the purchase agreement. So, key items that should be in every letter of intent, obviously, are, your purchase price, the payment terms, et cetera, how the purchase price is going to be paid. But really important things that I like to see in the letter of intent cover things like their indemnity obligations. And with indemnification, there's different ways that it can be structured in terms of whether we have what's called a basket, which is kind of like a deductible, where the claims have to hit a certain threshold before the indemnification kicks in. And then whether or not it's a tipping basket, which means that once you meet that basket or that deductible threshold, that then the indemnifier becomes responsible back to the first dollar, versus just a standard basket, which is, let's say it's $10,000. They're only responsible for any indemnification claims over $10,000.
And who's they?
So depending on who we're talking about, it'll either be the seller or the buyer. That works both ways in indemnification negotiations and the indemnification clauses that'll end up in the purchase agreement. But those terms, whether there's going to be a basket, whether it's going to be a tipping basket, are important to put in the LOI because that creates the framework for the purchase agreement. If it's not in there, what happens is the attorneys then start fighting over it during the purchase agreement on whether or not it should be in there and whether or not it was important enough to put in the LOI. So those types of, and those are more technical legal issues that, if the parties are just negotiating among themselves, they're not thinking about things like that.
They're definitely not thinking about things like that because they don't even know that exists, right? Mm-hmm. Talk to us about expectations and how the LOI really does set up expectations for the purchase agreement. And again, like you gave us that example of the basket, how not setting those expectations in the letter of intent can have a negative impact on negotiating the purchase agreement. You just gave us one little example. Are there other examples? Are there broad examples, specific examples?
Yeah. So another example of one where we had to go to battle with the other party. And in this transaction, I was representing the seller, and I came in after the LOI had been signed. And the buyer wanted to have what's called a holdback. Mm-hmm. So that is where part of the purchase price is then held back in an escrow account for a set period of time in case there are indemnification claims to pay those claims. And in that particular case, they didn't put it in the LOI, and then they tried to put it in the purchase agreement. And I was representing the seller at the time, and the holdback would only apply to claims against the seller, indemnity claims against the seller. So we pushed back on it and said, well, no, this wasn't in your LOI. And the buyer's counsel kept pushing for it to be in. And I finally put my foot down. I said, listen, if this was important to you, it should have been in the LOI. And it wasn't, so we're not doing it. And we ultimately won that fight. But how much did the client have to spend on me going back and forth with the other attorney to fight over this issue?
Yeah. One of the things that I encounter frequently, in fact, I have several transactions right now where I'm working with an owner who's selling to a key employee, mm-hmm. and they're friends. They've worked closely together for several years. And I've had this happen where when they come to me, they're not well-versed in the legal aspect of this transaction. And what they think is, in their mind, is that the seller and the buyer, remember, they're friends, they're holding hands, they're skipping toward this finish line where everyone's going to be happy and the seller's going to get their money and the buyer's going to get their business. And typically, oh, Ryan, we don't need to engage lawyers. Well, yeah, you do. And then, okay, well, we'll get one lawyer to represent us both. And I'm thinking, that's probably not going to happen. Can you talk to us about that specific scenario and speak to the people that are going to be watching this, how if they're engaged in that, right? From a seller perspective, they're selling it to a key employee, someone they've worked next to or with for, in some cases, 15, 20 years. how should they proceed with the sale so that they can keep it amicable, but also so both parties can be protected?
Right. And I see that a lot. I work in that scenario a lot. And it's never smart to have one attorney draft everything without separate counsel, because that attorney basically becomes a neutral. They can't take sides. They can't advocate for either party. But the whole process doesn't have to be acrimonious. It doesn't have to be adversarial. You can still have two M&A attorneys involved that are, reasonable minded, right? And they're aimed at getting the deal done, but they want to make sure that their respective clients are properly protected. So in that scenario, we always recommend getting counsel for both parties. I won't represent both parties in a single transaction, even if they're the best of friends and things look great, because sometimes things don't always turn out the way you want it to. And it's really important to know where your loyalties lie and where you can advocate for. So you can still have a scenario like that with the retiring owner, a longtime employee, and have a reasonable purchase agreement that isn't adversarial throughout the process and everyone ends up happy. And it doesn't have to cost a lot either, especially if they're, fairly well aligned on, the major deal points. The attorneys just need to come in and clean up these kind of legal nuances that the parties may not have thought of, come to an agreement on it, and put together a fair purchase agreement.
Thank you so much. Yeah, I really appreciate you sharing that. Let's talk about buyers now. And the type of buyers that I work with typically are going to be first-time buyers. They're not going to understand all the nuances of the process, including the SBA loan, but especially the legal aspect. Can you talk to buyers now? What should they primarily focus on or emphasize or prioritize with legal counsel? And then I'd also like you to share, who should they look out for? Because there are a lot of bad actors in SBA loan brokering, lending, and I'm sure there are a lot of attorneys out there that, let's just say, are less than savory and don't necessarily represent their clients well.
Yeah. So I actually gave a talk about this to the California Association of Business Brokers a couple of weeks ago on helping your clients, the buyers, pick the right kind of attorney, because there's a lot of people out there that do what we call door law, right? Which is anything that comes through the door, they'll help. So you don't want to ask your neighbor who's a personal injury attorney to help you with this transaction. You don't want to ask your best friend from college who's a family law attorney to help you with this transaction. You really need someone who's works and is well-versed in the M&A space and specifically in the small business size space. There's lots of attorneys who say that they can work on the M&A deals because every single attorney took a contracts class in college, and they all think, oh, well, it's just a contract. I can deal with that, right? But there's obviously a lot more nuances to this, as any M&A attorney would tell you. But then even within the M&A space, there's such a wide range of attorneys. There's attorneys that only try to work on deals over $25 million, right? They're not going to be a good fit for a business that's selling for $4 million. Or there's attorneys that say, oh, I work on deals from 1 to 100 million. And you think, oh, great, I'm within that range.
1 to 100 million.
But that's a really big range.
That's a big range.
Yeah. So, questions to ask is, what deal sizes do you typically work on? Like, what's your average deal size? Make sure that they're actually working in this area and are familiar with the smaller business transactions, because if they're not, if they only work on larger transactions, it's going to drive up the price. Whether they're usually at big firms, but whether they're at a big firm or a medium-sized firm, they're going to cost more. And quite frankly, they end up overcomplicating the deal.
Gotcha. Talk to us about some case studies that came through the door and you're really proud of how you were able to step in and represent that client.
So I had a seller earlier this year who was selling a business within the construction industry, and it was around a low $2 million sales price. And the other side came in and brought us an 80-page purchase agreement. And the purchase agreements are usually around 30 pages.
80 pages.
This one was 80.
Sounds like some loan docs.
Yeah, for a $2 million sale. And that was not even with the all the different ancillary documents, because apart from the purchase agreement, there's other ancillary documents, your bill of sale, your transition services agreement, maybe an employment agreement, non-compete agreements. Like that didn't even include all those little separate side agreements that we have in a transaction. And so I had to sit down with the client and say, listen, like if I sit here and I redline out everything that doesn't apply to you, like your bill is going to be astronomical. And, you know, because we're going to have to go back and forth with the other side so many times. And I just don't think it's a good use of your money. So I said, what I'm going to do is just go in and I'm going to just redline things that are important to you that we care about. And let's narrow this down. If it doesn't hurt you, if it's non-consequential to your business, I'm just going to leave it there and leave it alone. So that was the approach that we took. We obviously had a big firm on the other side. And so we did get that deal closed. You know, we only had, I think, 2 or 3 rounds of red lines back and forth on the purchase agreement, which is pretty impressive for an 80-page document. Mm-hmm. And we did take that all the way to the finish line and closed it. And my client's fees were incredibly reasonable compared to the other parties.
That's great. Before we go to the next case study, what I'd like to do is just sit on that. And can you talk to us about what is important from a buyer's perspective? What should they be protected from?
Yeah. So when I'm going through the purchase agreement, there's a couple of areas that I pay the most attention to. Obviously, I'm comparing it to the LOI and making sure, you know, all the payment terms and such align. But the one area from a buyer's perspective that I pay a lot of attention to is a section with the seller's representations and warranties. Because in most deals, that is the section that has everything that the buyer can rely on in moving forward with the deal. It doesn't matter anything that you saw or learned about in due diligence. What's in that representations and warranties section is legally what they're relying on. So it's really important from a buyer standpoint that those are beefed up as much as we can. And there's standard typical ones that we have in all the agreements, but you know, we want to make sure there's representations and warranties regarding the financial statements, that they're true, they're accurate, that there's no material omissions from them. Employees are really big. A representation warranty that all the employees are properly classified, they've been properly paid, that there's no known pending or known claims, because those tend to bite parties in the butt later. And intellectual property representations and warranties are important if there's any sort of intellectual property. Every business is transferring intellectual property in some form, but we're really kind of concerned about especially those that are registered or potentially could be infringing. So I'm talking trademarks, copyrights. So we want representations from the seller that they own it, that it doesn't infringe, that they've received no notice that it might infringe, so that the buyer can go into this deal with a clear conscience that they're not going to get hit with a claim of infringement or an employment claim or anything like that after the closing.
And what have you seen from a purchase agreement perspective where there's something missing, maybe regularly, maybe infrequently as well, but that you think should really be in there for the buyer? Does that happen?
There's a provision I like to add in when I'm representing buyers that sometimes we can get in and sometimes we can't. But basically that the representation warranties are complete and there's no material omissions that would affect the buyer's decision or the value of the business. So I kind of like to put like a catch-all provision in there.
When I was at Torrey Pines Bank, my attorney, Bob Casey, he called that the zipper clause. It just zips everything up.
Yeah.
Wonderful. Do you have any case studies for buyers?
Where I've represented the buyer.
Yeah.
Well, I've represented plenty.
Yes.
Let me think about. Yeah. So there was a matter where I represented the buyer, and I was pulled in pre-LOI, which was good. So we negotiated the LOI and went into the purchase agreement. And in that case, I drafted the initial purchase agreement, and then the seller retained a large firm who redline the heck out of the purchase agreement. And again, I take the point of view of if it doesn't hurt us, like we're just going to leave it alone, right? And so there's, a little bit of tug of war, but overall it was a fairly smooth process. But that was due in part to the fact that we were involved with the LOI. So we addressed all of those major issues that would go into the purchase agreement up front. So that made the purchase agreement process much smoother, even with the big firm kind of marking things up on their end.
Got it. Can you talk to us about an instance where you worked with a buyer that didn't know anything? I mean, they came into this, maybe the opportunity to buy wasn't even something that, again, maybe a key employee transaction, they weren't even ready for it. Mm-hmm. And how do you walk them through the process to make sure that they understand this is what you need to do? A lot of people I speak with, they're so fearful about legal fees. Mm-hmm. And so their first default reaction is, well, either I won't use an attorney or I'll try, like you said, use a friend. So talk to them about why they need to use an attorney and why these fees, these costs are, even if they kind of start escalating because of maybe the other side, there's still costs that they need to incur because it could cost them a lot more later if they don't use an attorney that understands the space. Yeah, absolutely. So with the buyers that have kind of no business experience, mm-hmm. They're actually really fun to work with because they're new to it. And so there's a lot of education, but they're so excited and passionate about their new venture. So I do like to sit down and kind of walk them through the key points of the purchase agreement. What does this really mean for you? Why is this important? And for them, I tend to get a little bit more involved in the due diligence process. Again, as much or as little as they want, but they don't know what they don't know. And fortunately, they're smart enough to realize that. So, we'll go through things like, looking at the lease and, what does this mean for you? If this lease is assigned to you, how long are you actually going to be on the hook for this? Looking at the key customer contracts of the seller and making sure that they're assignable and that they're going to actually, inherit those relationships that they think they're buying. And then kind of talking them through some of the basics of running a small business. Mm-hmm. So I'll help them, they don't have an entity, we'll help form the entity and talk to them about, kind of what they need to be doing going forward to make sure that they run their entity and their business properly mm-hmm. in order to protect themselves personally from any liability and trying to, keep all that liability within the business itself and not let it extend to their personal assets. Got it. And this is a great segue now because I want to ask you if you can simply, I don't need you to go, I won't go too deep, but educate the audience. What are the basic differences between a purchase an asset purchase and a stock purchase or a membership interest purchase?
Sure. So most of the work that I do, I would say most of the deals that I see are asset purchases. And what that means is that the buyer's going in and they're purchasing usually all of the assets, but sometimes specified assets of a business. And so that would be things like the customer lists, customer contracts, furniture, computers. Sometimes it includes inheriting the lease, the employees. But with an asset purchase, the buyer has their own business entity, mm-hmm. which might be a corporation or LLC. And so all of that gets purchased and brought into their entity. And likewise with employees, they then, if they want to keep the same employees, they hire those employees under their entity. And the advantage to an asset purchase is that you can pick and choose what liabilities, if any, that you want to inherit. But with a stock purchase or a membership interest purchase, you're buying the ownership in the business itself, which by definition is going to include all of the assets. So if you go in and you buy all the stock of a corporation, you become the new owner of that corporation and everything that it owns. But the danger or the downside in doing a stock purchase or a membership interest purchase is that you also, by definition, are buying all of the liabilities and debts of that corporation or LLC. So there's a little bit of risk, but sometimes stock purchases are necessary if you have key customer client contracts that can't be assigned. because with a stock purchase or a membership interest purchase, there's no assignment necessary because those contracts still remain in place with XYZ Corporation or XYZ LLC. There's no assignment necessary. So you can keep those key customer contracts in place. So if they're not assignable or they're concerned about disrupting that key customer relationship, a stock purchase is a good option.
And what can a buyer do to mitigate their downside risk when executing a stock or a MEPA, membership interest purchase?
The best thing that they could do is really thorough due diligence to understand where all the bodies lie.
Mm-hmm. Where the risks are.
Yeah, exactly. And then, for some things it's pretty typical, if the company has an outstanding line of credit, for example, it's pretty typical to require that to be paid off, at the closing. So there's certain things you can make sure are paid off in terms of the debts and stuff. The liabilities are something that you can't really guarantee against. You could do some good due diligence to understand where the risks are. And then you're going to really fall back on your indemnification clause so that if any of those liabilities end up popping up later, that you're able to go back to the seller and say, hey, you need to come pay for this.
Got it. Well, this has been fascinating. Thank you so much for diving deep on these topics. And what I'd like to do now is transition to your work as general counsel for these business owners when you help them buy the business. And then I'm sure most of the time, if not all the time, that transitions into a relationship with that business owner beyond the sale. Can you talk about transitioning with that business owner, how you help them transition, and then how you act as general counsel after the purchase?
Yeah. So taking just like a tiny step back during the purchase, if the buyer doesn't have a business entity set up, then that's where we kind of start that second half of the relationship by either putting together a corporation or LLC for them in an asset sale, occasionally in a stock sale, but not necessarily, but getting their entity together for them. And then after the transaction closes, then I'm there to assist on an as-needed basis. Some people have me involved a lot. Some just want to bounce some questions off of me. Either way is fine. Making sure that all the kind of open items from the sale are buttoned up, right? That we've transferred over business names, that the contracts have been assigned, that we have, everything's starting to transfer over, that their employees are now set up on their own payroll. And then going forward, we really kind of serve on an on-call basis, as needed basis for these clients. But I generally tend to work a lot with them when they have contracts. Either they need to write a contract, but usually they have those in place and they need that contract beefed up, or they've been given a contract by either a client or a vendor that they've been asked to sign. And the general rule is you should not sign a contract unless you know and understand every single provision in there, and most non-lawyers don't. So that's where we come in to, review, and I've reviewed so many different types of contracts over my career that I have a pretty good sense of what's typical and what's not, that I can call out to the client and be like, hey, this contract like this, I don't normally see here. So you may want to, maybe counter with a different term or try to remove it altogether.
Got it. Yeah, well, I really appreciate that. And do you get questions post-close from your buyers about, hey, did we make sure that, I de-risked in this area, or this has come up? Do you get those questions a lot, or does it not happen that much?
Not a ton, but every once in a while where, you wake up in the middle of the night and you go, oh my God, did I cover that? So I do get those sometimes where they're like, hey, did we address this? And I'm like, oh yeah, that was in the purchase agreement. It's over here in this section.
Awesome. Well, thank you for joining me. You have a great reputation in the M&A space and the overall legal industry here in San Diego. I don't want to end the podcast yet. I'm going to ask you a question that we did not discuss, but you're going to be able to answer this, I have no doubt. Can you tell us how AI is impacting your industry, and where do you see AI in your industry within the next 10 years?
So AI is impacting us. And the primary way that I've seen it is that clients will go to AI chatbots, primarily ChatGPT, and ask it to write something that they would have asked the lawyer to do. So I've had clients write contracts using ChatGPT and then send it to me and basically ask me to bless it. Now I come from the standpoint of I'm always willing to review an existing document, whether, a client drafted document, for example. And so I don't treat AI any differently. I'll say, okay, I'm going to charge you for it, obviously, but I'll sit there, I'll review it, and I will mark it up and change it and put my spin on things. The AI tools out there they're okay. They're not great for the legal documents. They do a decent first draft, but there's a lot of nuances that they don't get, that, the attorneys still have a role in. And then within the industry as a whole, AI it's a really useful tool. I use it for kind of sanity checks on things. So I'll run documents that I've finished my draft or my review of, and I have an AI tool that I'll run it through to say, hey, catch this. Did I miss anything? And sometimes it does. Sometimes it'll be like, hey, you have an inconsistency between these two paragraphs. Like, oh, look at that. There is. Then I can go in and fix it. But I don't really I don't rely on it for drafting. They're not reliable enough, at least not yet.
So what you just described, that's an industry tool?
So what I just described is an AI-specific tool that the company only sells to lawyers.
Oh, fantastic.
Yeah.
Yeah, I could see how that could be, again, we're human, we're busy, and these contracts, as you had already mentioned, tend to be long. So if AI can quickly, for example, like you said, outline a discrepancy or something that goes against what you had said previously, that's pretty helpful.
Yeah, and it'll identify missing provisions, but then I have the option of saying yes or no. And, sometimes they're intentionally not put in, and I can say, nope, we're not going to add that. And what it's really done is it saves the client money instead of me taking it to another attorney in my office and saying, hey, I need you to review this. I need a second set of eyes. So it saves the clients money that way. So
no one can predict where we're going to be in 10 years, but if AI continues to develop at the rapid pace it is today, how can you see AI affecting lawyers, maybe interns? Do you think that there will be less lawyers because of AI? Do you think people that want to be attorneys maybe are thinking, well, this is an industry that'll be greatly impacted by AI? What are your thoughts on that?
Yeah, I think the challenge is that with the tool that I just described is it reduces the need for associate attorneys, baby attorneys. And so as more and more lawyers use those types of tools, we have less of a need for baby attorneys. But then how are baby attorneys going to get jobs and learn and fill in the practice gaps as older attorneys retire? So I think it's going to create a problem probably 10, 20 years down the road, maybe even less. I don't know. It's developed so much in just the last couple of years. But that would be the concern. And then how do these young lawyers learn if, the law firms don't have the work to train them on it?
You had in your practice at one time were a litigation attorney. How do you see AI entering the courtroom? Is that something that they're talking about, or is that something that'll be untouched?
There's been some discussion about it, and there's some attorneys that are very confident that the clients can't replace them in the courtroom, right? They don't have a license to practice law. But there are some people out there that are really concerned that AI is going to be good enough that's going to allow more and more clients to go in pro per, which is self-represented. In other words, they're going to go in and try to handle their case without a lawyer, which you're allowed to do legally, as long as you're not representing others. So individually, you could go in and file a lawsuit without a lawyer and rely primarily on AI.
And so would they be in the courtroom prompting AI for rebuttals, all those legal things that happen in the courtroom?
Well, they could try on the spot when you're in a hearing or in trial. You're not going to have enough time to type that out and get your answer as fast as AI is. Like, you got to be thinking on the spot, on your feet, when you're in the courtroom. So that's going to be challenging. But in terms of, drafting documents and such, like AI potentially could help these self-represented litigants do better in the court.
All right. Well, thanks for answering that question you weren't ready for, but you were ready for it.
Right.